Good morning, and thank you for your time today. My name is Deborah Tyler, and I represent Product Architecture and Design, LLC, commonly referred to as PAD. We appreciate the opportunity to participate in mediation and remain committed to resolving this matter efficiently and in good faith. At the outset, Pat recognizes that the library's concerns regarding the performances of the exterior wall system. No one disputes that the library has experienced problems involving a black substance dripping from portions of the building facade. The issue before us is not whether a problem exists, but who bears the legal responsibility for that condition and to what extent. Now, the library alleges that PAD breached the architect agreement by specifying incompatible materials, failing to satisfy the applicable professional standard of care, and failing to notify the owner of alleged design deficiencies. Respectfully, the evidence developed to date does not establish those allegations. Instead, it demonstrates a complex construction dispute involving multiple participants, shared contractual responsibility, and unresolved questions concerning causation. The architect agreement incorporates AIA document B101-2017, section 2.2 requires an architect to perform services consistent with the professional skill and care ordinarily provided by architects practicing under similar circumstances. Likewise, the Illinois Architecture Practice Act of 1989, 225 ILCS 304/6 requires architects to prepare technical submissions using reasonable professional skill and diligence. Neither authority makes an architect a guarantor of perfect construction results. The applicable standard is a reasonable professional judgment, not perfection. Perhaps the most significant evidence comes from the deposition of the library's own engineering witness. He admitted he could not testify that PAD actually knew about the alleged incompatibility before construction. He further testified that the manufacturers ordinarily disclose compatibility limitations within their product specifications and acknowledged that both the owner's representative and the general contractor reviewed project documents. He also confirmed that an independent engineering report concerning installation had not yet been reviewed, leaving unresolved whether installation practices, contractor performance, or manufacturer disclosures contributed to the condition. The complaint itself alleges that IHC failed to submit compatibility documentation required by the project specifications and failed to inspect and notify the owner of the problem. Those allegations reinforce that the responsibility, if any, may be shared among several project participants rather than resting solely with PAD. The parties also negotiated a limitation of liability provision in the architect agreement. That clause provides that PAD shall not be liable for indirect, incidental, consequential, or special damages unless the library proves gross negligence or willful misconduct. The evidence presently before the parties do not establish gross negligence or willful misconduct, making the scope of recoverable damages a significant issue should this matter proceed further. From a practical perspective, Continued litigation will require extensive expert testimony in architecture, engineering, construction, materials, material science, and product compatibility. The cost of additional discovery, expert reports, depositions, depositive motions, and trial preparation will be substantial. Mediation provides an opportunity to resolve the dispute before those expenses escalate any further. PAD is not here to minimize the library's concerns by any means. Rather, PAD respectfully submits that the current evidence does not establish that PAD alone caused the alleged damages or breached the professional standard of care required by the architect agreement or Illinois law. The unresolved issues regarding causation, the contractual allegation of risk, and the independent obligations of IHC, subcontractors, manufacturers, and the owner's representative all support a balanced allocation of responsibility. For these reasons, Pat asks that today's mediation focus on a fair, evidence-based resolution that reflects the governing contracts, the applicable law, and the realities of the construction process. We appreciate the mediator's assistance and remain willing to work collaboratively toward a commercially reasonable settlement. Thank you.